This is the Vinson Court, and this is the U.S. Supreme Court that decided a case called Youngstown Sheet and Tube Company v. Sawyer. This case was decided in 1952, and it has to do with presidential authority. Here we go. At the time this took place, the United Steelworkers of America were quite upset, and they were saying, we're going to go on strike. This was quite upsetting to President Truman because we were in the midst of the Korean War. This was in April of 1952. He went forward and issued an order saying that the Secretary of Commerce had to seize and operate most of the nation's steel mills in order to avert the strike from occurring. This got appealed all the way up to the U.S. Supreme Court, and the question was very simple. Did the president have the constitutional authority to seize and operate the steel mills? This question became complicated because at the lower court level, the court held the president went too far with his executive order. When it was appealed, the Court of Appeals said, it's fine, the president can do this, no problem. That's why the U.S. Supreme Court needed to get involved in order to set the standard here. And what they said was, there was no express or implied powers anywhere written in a statute or in the Constitution that gave the president the authority to take over this kind of an industry. And because the authority was nowhere within the law, it was outside of the scope of his authority. Now, they did argue perhaps it was under his war powers authority, but the Supreme Court said, we'd like to remind you that the Korean War has not officially been declared a war, and therefore the presidential war powers do not apply in this particular situation. Therefore, the executive order was held unconstitutional, not allowed. President Truman was very upset about that, but that's just how things went down. So when it comes to presidential power, there can be some limitations. Not only that, but we also have to be careful when we're using the umbrella term of war powers, and there actually has to be a declared war on the table in order for those powers to be invoked. There you have it, a very interesting case regarding President Truman's fight with the U.S. Supreme Court over an executive order. This is Chief Justice Earl Warren, and he wrote the opinion for the court in an 8-1 decision on a case called Flast v. Cohen, and that was decided by the U.S. Supreme Court in 1968. This case has to do with whether or not taxpayers can sue. At the time, Congress passed an act to give some funding to schools through the Education Act. There were some troubles going on, and the funding was necessary. Now, there were a group of people out of New York who were taxpayers, and they said, we don't want our tax money going to religious schools, because some of that money could be given to different schools, and it didn't matter if they were religious or not. So these taxpayers sued all the way up to the U.S. Supreme Court. It goes, we have a precedent, the Mellon case, that states a taxpayer cannot sue because they don't like a statute and they don't like where their tax money is going. Based off of that precedent, the government thought they had a pretty strong case. What we didn't know would happen was Chief Justice Earl Warren set out a new test, and we call it a double nexus test, to determine whether or not a taxpayer has standing to bring a lawsuit against the federal government. In this case, it was the Secretary of Health and Education, Secretary Cohen. In this test, he said there are 2 pieces that have to be met in order to see if there is standing. Now, legally, if you don't have standing, it means your case is going to get tossed because you can't bring the case in front of the court. So here are the 2 pieces that are required. First, the taxpayers have to establish a logical link between their status as taxpayers and the type of legislative enactments attacked, and 2, show that the challenged enactment exceeded specific constitutional limitations imposed upon the exercise of congressional taxing and spending power, which is set out in Article 1. In this particular situation, the court held that the petitioners had satisfied both prongs of the double nexus test, so they did have standing as taxpayers to bring a lawsuit against the federal government. So we have a brand new standard, the double nexus standard, when it comes to taxpayers and filing lawsuits against the government because of where their tax money is going. This is Chief Justice William Rehnquist, and he wrote the opinion for the court in 2005 called Van Orden versus Perry. This case had to do with a monument that was being displayed on government property. At the Texas State Capitol building, there was a monument on its grounds, and that monument listed the Ten Commandments. The petitioner claimed that this monument on government grounds violated the freedom of religion piece to the First Amendment. Specifically, he was talking about respecting the establishment of religion. So we're dealing with the Establishment Clause of freedom of religion. The Establishment Clause under the First Amendment bars the government from passing any law that establishes a particular religion. Now, the Ten Commandments are from a particular religion, and that's why the petitioner went forward and said, hey, I believe my religious freedoms are being put to the side for the religious beliefs that include the Ten Commandments. This was a 5-4 decision. Justice Rehnquist went forward and said that the Establishment Clause did not ban the use of having the Ten Commandments on a state capitol grounds in Texas. In particular, he relied on the extensive history of the Ten Commandments' historical meaning and what that meant in Texas. Ultimately, the court said by just having the Ten Commandments or some kind of religious content promoting a particular message that goes along with a religious doctrine, just by having that kind of content available or on government grounds, did not violate the Establishment Clause of the First Amendment freedom of religion. So this case was dismissed, and the Ten Commandments were allowed on government property. The next case in our series on whether or not the Bill of Rights apply to the states is a very, very famous set of cases that we call the slaughterhouse cases. These cases were decided by the Chase Court, so these fellas here, and this case was decided in 1873, and it was one of the first cases the U.S. Supreme Court had to try to figure out how the 14th, 13th, and 15th Amendment applied to the states after the Civil War. Here's what happened. So Louisiana had passed a law that restricted slaughterhouse operations in New Orleans. There was a whole bunch of runoff issues and companies that were upstream and what would happen downstream. So there was a law put into place to try to restrict the operations. Now, there was one particular company that was chartered to provide all of the slaughterhouse business, and this one company ultimately became a monopoly because they were the only ones given the right to do this kind of business, according to the Louisiana state government. Now, after all of the other slaughterhouses were closed, they were pretty upset. So they petitioned the court, and they argued that a monopoly was creating, first, an involuntary servitude, which was a violation of the 13th Amendment, and also abridged privileges and immunities, as well as denied equal protection under the 14th Amendment. And of course, we've got to toss in that due process element as well. So that became the question in front of the U.S. Supreme Court. Did the creation of this kind of a monopoly violate the newly ratified 13th and 14th Amendments? The U.S. Supreme Court, the Chase Court, came back and very controversially held that the 13th, 14th, and ultimately the 15th Amendments were very narrowly intended to only cover former slaves and any issues dealing with former slaves. Because this case was not dealing with former slaves, they held that it did not apply to the state of Louisiana, and therefore there were no grounds upon which the slaughterhouses could sue. So, very narrow interpretation. What's interesting here is the dissent. It was Justice Field who wrote a dissenting opinion claiming that this was too narrow a view of the 14th Amendment. And he said, this isn't about just former slaves. This is about everybody and their rights in relation to the states. So this dissent is what is cited in subsequent cases where the U.S. Supreme Court, step by step, has been incorporating pieces of the Bill of Rights to the states. This is Justice Potter Stewart, and he wrote the opinion Ferretta v. California, and this case was decided in 1975. So here's what happened. The defendant was charged with grand theft. He was located in Los Angeles County. When it came his turn to go to court, he said he wanted to represent himself. Initially, that seemed okay. The judge later called him back in, asked him some questions about hearsay and other court procedures, and based off of his answers, the judge decided he was unable to represent himself. Specifically, the judge held that the defendant did not intelligently and knowingly waive his right to counsel. Therefore, the judge then appointed defense counsel. Off it went to court, and he was found guilty. He appealed, and the California Appellate Court said that the lower court had held appropriately, that the defendant was unable to represent himself. Up to the U.S. Supreme Court it goes, and here is the question: can a defendant be denied the right to present his own defense and therefore be forced essentially to accept the representation appointed by the court? This was the question in front of the U.S. Supreme Court. Justice Potter Stewart, this guy, held that his constitutional right for counsel had been violated, and he did have a right to represent himself. So he vacated the lower court's decision and the verdict, and said further that just not having the knowledge of hearsay rules or court procedure does not have a significant effect on whether or not a defendant can voluntarily and intelligently waive his right to counsel and represent himself. Therefore, because this was completely voluntary, he had the right to go forward. His case was then reversed and sent back down to be tried. This is Justice Taney. Now, this case that I've got for you today is so fascinating. It wasn't actually decided by the U.S. Supreme Court, but Justice Taney was the U.S. Supreme Court Chief Justice at the time, but he ruled on this case as his role as a circuit judge. So here we go. Ex parte Merriman. And this case was decided in 1861. Here's what happened. So we've got the Civil War going on, and President Lincoln had suspended habeas corpus. And he had done this under the authority of the Constitution. Under Article 1, Section 9 of the Constitution says, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. So that's the suspension clause in the Constitution. Now, Congress wasn't in session, and so President Lincoln suspended it on his own and commanded the military to follow his order. Mr. Merriman was part of the rebellion and was a lieutenant with 500 other armed men trying to overthrow the government, essentially, that time. And he had a significant roles to play in the destruction of bridges, in different telegram processes, as well as some participation in a mob that had occurred in Maryland. He was arrested and taken to Fort McHenry. Now, while he was at McHenry, he hadn't been charged. So this case was then shown to Justice Taney, and Taney's like, what's going on? Why isn't he charged? And the answer came back, President Lincoln had suspended habeas corpus. So Taney had commanded the general at Fort McHenry to bring Merriman in front of him. And the general said, I can't. I've got an order here that says I'm not allowed to do that. So Taney then charged the general with contempt of court and sent a U.S. Marshal to Fort McHenry to bring Merriman in front of Taney. Now, the U.S. Marshal wasn't allowed into the fort, and so he was unable to get the defendant in front of the judge. In the end, the judge was so upset, he held that President Lincoln did not have jurisdiction to suspend habeas corpus. But in the end, it didn't really matter, because a couple of years into this whole fiasco, Congress passed the Habeas Corpus Suspension Act, which did make it possible for a sitting president to suspend habeas corpus. So, fascinating case on judicial jurisdiction. This is Chief Justice John Marshall. He was our very first U.S. Supreme Court Chief Justice, and it was his court that decided a case called Barron v. Baltimore. And this case was decided in 1833. This will be the first case in a series explaining the selective incorporation doctrine, setting out that not all the Bill of Rights apply to the states. Stay with me here. Here's what happened in this case. We have Mr. Barron, and he was a wharf owner. Now, he was having some problems with his profits because of some construction that Baltimore had been doing. It had to do with some water issues, so he decided to sue Baltimore. He was looking for some monetary amount of recoverable damages that had been done due to this type of construction. So all the way up to the U.S. Supreme Court it goes. And the question was, does the Fifth Amendment deny the states as well as the national government the right to take private property for public use without justly compensating the property's owner? We're dealing with a Fifth Amendment question on just compensation for the government takings clause. Justice John Marshall came back and he held, writing for a unanimous court, very clearly the Fifth Amendment and all of the Bill of Rights only applied to the national government and not to the states. And therefore, Mr. Barron could not get a remedy under the Fifth Amendment because it did not apply specifically to Baltimore. This was very controversial, and as time goes on, you'll see that it was after the Civil War, through a set of cases that incorporated almost all of the Bill of Rights through the 14th Amendment, that has allowed those Bill of Rights to be applicable to the states. But this case set out the law stating very clearly the Bill of Rights only applied to the national government. Stay tuned for the next case in this series. Let's talk about a very famous case that has been in the press quite a bit lately, and it's called Hurley v. Irish American Glib Group of Boston Incorporated. This case was decided by a unanimous Supreme Court in 1995, and it has to do with whether or not a group of people wanting to throw a parade had to include another group of people that they disagreed with ideologies on. Let's get into the case. In 1993, the South Boston Allied War Veterans Council had obtained a permit for a parade to celebrate St. Patrick's Day. Now, there were lots of reasons why they wanted to celebrate, and one of those had to do with the Roman Catholicism that was behind the idea of St. Patrick's Day. They were given this permit and were organizing this parade, and there was a group that had newly formed called the Glib Group, and they wanted to be a part of the parade. And in that parade, they would have a sign with the name of their group on it. Now, the War Veterans Council had denied this group to be a part of their parade because of religious reasons, and they disagreed with the principles of the group. This group had to do with biologically assigned gender at birth and romantic relationship preferences. Now, Massachusetts had a law in place saying you could not discriminate against this class of people, and said you have to allow them to participate in your parade. All the way up to the U.S. Supreme Court it went. In a unanimous Supreme Court, it came back and said, here is the question presented to us. Did a Massachusetts state court's mandate to Boston's Veterans Council requiring it to include Glib members in its parade violate the council's free speech rights as protected by the First and 14th Amendment? And the U.S. Supreme Court unanimously came back and said, yes. And specifically, they said, requiring private citizens who organize a parade to include a group expressing a message that the organizers do not wish to express violates the First Amendment by making private speech subordinate to public accommodations. Specifically, the court went on to say, quote, such action violates the fundamental First Amendment rule that a speaker has the autonomy to choose the content of his own message and conversely to decide what not to say. Ultimately, the Supreme Court held that a specific message can be discriminated against, and Hurley won the lawsuit, and they were not required to allow them into their parade. This is Chief Justice John Marshall, arguably one of the most important Chief Justices we ever had on the U.S. Supreme Court. He wrote the opinion for a case called Cohens v. Virginia, which was decided by a unanimous court in 1821. Here's what happened. In Washington, D.C., there was a statute that was passed that said that lottery tickets were allowed. There were two brothers in Virginia who decided to sell lottery tickets and were arrested because in Virginia it was against the law. They were convicted and fined for this. They appealed all the way up to the U.S. Supreme Court, and the question became, did the U.S. Supreme Court even have jurisdiction to hear this case? So we're talking about a separation of powers. The unanimous U.S. Supreme Court held, yes, anytime there is a constitutional question, anytime, if it's in a criminal case, and no matter what state it's in, the U.S. Supreme Court will have jurisdiction. So all constitutional questions will be decided by the U.S. Supreme Court. And if there is any state constitution with a piece of it that is in violation of the U.S. Constitution, it will be voided. In this case, we've got two conflicting laws. So we've got the D.C. law, we've got the Virginia law. And in this case, the U.S. Supreme Court said, first of all, yes, we do have a constitutional question. So we're going to answer that. Yes, we can hear your case. It doesn't matter what state you're from. And the second question was, yes, Virginia can go ahead and cite you for violating a law in their state and you can be fined. Therefore, the conviction was upheld, and Chief Justice John Marshall again established for us this huge precedent setting out anytime there's a question regarding the Constitution, that's going to be the jurisdiction of the U.S. Supreme Court. And again, if that state constitution conflicts with the federal constitution, that state constitutional law will be voided. There you have it, historical case involving who has the power and who has jurisdiction when it comes to the Constitution. This is Justice Gray, and he wrote an opinion for a unanimous court in 1893 called Nix v. Hedden. Mr. Nix was a fruit producer, and he was very successful with producing his fruit and was actually the only one shipping fruit from Virginia, Florida, and Bermuda to New York. President Arthur had signed a Tariffs Act that had put tariffs on vegetables, but not on fruits. The question became, is the tomato a fruit or a vegetable? That's actually a question the U.S. Supreme Court decided to answer. They had lots of different people come in and read into the record dictionary explanations of a tomato and various things because botanically, because the tomato has seeds, it's classified as a fruit. But the common knowledge of a tomato is that it's a vegetable. The U.S. Supreme Court decided, they understood, yeah, botanically it's a fruit, we get it, but everybody thinks it's a vegetable, so we're gonna go ahead and classify it as a vegetable for purposes of any tariffs, imports, and custom regulations. This case is so interesting because they are literally putting aside the fact that it is scientifically, it is a fruit, and just declaring, we don't want to have to deal with this, we're going to call it a vegetable. Unfortunately, Mr. Nix then had to pay all of the tariffs when it came to shipping tomatoes because they were vegetables, and that is what the tariffs were on. This is the Burger Court, and they decided a case called New York Transit Authority versus Beezer in 1979. We've got two men who were heroin addicts, and they were undergoing methadone treatment to treat their addiction. The New York Transit Authority had a very, very strict policy regarding hiring anyone using narcotics. The use of the methadone was seen as the use of narcotics, And once that was discovered that these men were undergoing this type of treatment, they were terminated. They brought a class action suit for discrimination against the New York Transit Authority, claiming that they were fired due to discriminatory policy. Justice Stevens, who wrote for the majority court, came in and said, where we have a public entity who has an employment policy that is rationally related to a justifiable ends, in this situation, we do not have a protected class of people. And so it's a very, very low rational basis standard in order to determine if a policy is discriminatory. So in this case, they found that this policy that was very strict against hiring anyone using narcotics was absolutely fine and not discriminatory under the 14th Amendment Equal Protection Clause. So the case was thrown out. This is the Warren Court, and they decided a landmark case in 1964 called Reynolds v. Sims. This has to do with voting apportionments. So here's what happened. We had some voters in Jefferson County, Alabama, and they were challenging the apportionment of their state legislature. They were claiming that the citizens were not being properly represented because of this apportionment. So up to the U.S. Supreme Court it goes. Their entire argument was based on the fact that a dramatic population discrepancy made it virtually impossible for them to participate in a Republican form of government, and therefore their equal protection rights under the 14th Amendment were being violated. Now, the Warren Court came back and said that equal protection requires that districts be comprised of equal populations if possible. They held that the Alabama apportionment was unconstitutional because of how it had not been equally proportioned out. Now, when we're dealing with any kind of a situation where we have voting right in question, they're going to apply this kind of a standard to it. In the end, the Warren Court held that states need to have an honest and good faith effort in having this kind of equal representation across the board when it comes to state legislatures. So, very important case, first on whether or not our judicial system can step in for a state legislative apportionment situation. Yes, they can. And also, what kind of apportionment is appropriate under the 14th Amendment. And the kind is as equal as possible with a good faith effort on behalf of the states. So there you have it, Reynolds v. Sims. This is Chief Justice John Roberts, and he decided a case in 2020 called Americans for Prosperity versus Bonta. Here's what happened. In California, we've got a statute that is requiring the disclosure from major donors to help the state protect consumers from fraud and the misuse of charitable funds. So, for charities, if they've got major donors, their name and addresses were required. There was a particular person who did not disclose, and the Attorney General's office in California was trying to force him to disclose that information. He claimed that he had a freedom to associate, and he felt that this kind of a statute would hinder people from donating to different causes because that information would not be kept private. Now, the state argued and they said, we're going to keep your information private, but in reality, there's no absolute way that that information would remain private, and the court acknowledged that. So up to the U.S. Supreme Court it goes, and the question became whether or not this statute violated the First Amendment right to associate, the freedom to associate. So the U.S. Supreme Court used a standard that they had set out previously in the NAACP versus Alabama case. And in that case, the standard was, we have to see if the government used the least restrictive means possible in order to achieve their goal. Now, their goal here was to try to prevent and protect consumers from fraud from charitable organizations. And the court felt that this statute was not the least restrictive, and therefore the statute did violate the Constitution. So the statute was thrown out as unconstitutional. The disclosure was not required for this particular entity nor any other entities. So there you have it, a very interesting case out of the U.S. Supreme Court in 2020. This is the Roberts Court of 2020, and they decided a case called Tanzan versus Tanvir in 2020. This case has to do with the Religious Freedom Restoration Act and whether or not individuals are allowed to sue federal employees. In this particular case, we have some FBI agents. Let's get into the facts of this case. The plaintiffs were Muslim. They had come from outside of the United States, had completed all their paperwork, and were legally, legitimately living in the United States. They were approached by a couple of FBI agents who had asked them to become informants for the FBI. Now, these men had decided, based off of their religion and their beliefs and the situation, that they did not want to become informants for the FBI. So they turned down the agent's offer. After they had said they wouldn't become informants, all of them had been placed on a no-fly list. The no-fly list has been set out by the United States government in order to make things a bit safer for everybody. And if you are placed into the database, your ability to travel will be significantly hindered, hence the no-fly list name. This, of course, was completely unacceptable to the plaintiffs, and so they sued the agents. And they sued on First Amendment grounds, freedom of religion, as well as Fifth Amendment grounds of due process, because they had been placed on this list without due process of law. All the way up to the U.S. Supreme Court it went, and they had to answer this question. Does the Religious Freedom Restoration Act of 1993 permit lawsuits seeking money damages against individual federal employees? Now, there are a few things going on here, but they're specifically looking to the language in the act that did allow for civil litigation against the government. But what exactly government meant in the act was something that they needed to figure out. Justice Thomas wrote the opinion for the court, and it was a unanimous decision. And they had decided that when it came to this term and meaning of government within the words of this particular act, that it did actually cover these FBI agents. And that meant that it was possible then for the plaintiffs to go forward in a lawsuit against these agents. This was a huge moment because qualified immunity under the Bivens case had really been pretty significant when it came to federal employees. But in this case, they said because of how the statute was written and the language included in that statute, it did permit civil lawsuits. They held for the plaintiffs, and plaintiffs were then allowed to go forward in a lawsuit against the FBI agents if they so chose. There you have it, though, a very significant case from the U.S. Supreme Court where they're chipping away at the qualified immunity that has been given out throughout the decades when it has come to federal employees. This is Justice Antonin Scalia, and he wrote the majority opinion for a case called Scott versus Harris that was decided by the U.S. Supreme Court in 2007. This case has to do with police chasing a suspect, then using deadly force in order to stop his vehicle, and whether or not that was a violation of the Fourth Amendment right to be free from unreasonable searches and seizures. Let's get into the case. Law enforcement was attempting to pull over Mr. Harris. He decided to flee in his vehicle, and then a chase occurred. Because of the chase, the police rammed into his vehicle, and this resulted in a huge accident which left Mr. Harris a quadriplegic. Mr. Harris sued, claiming excessive force, and all the way up to the U.S. Supreme Court it went. Now, when we're dealing with excessive force and law enforcement, we have to overcome qualified immunity. And in order to do that, we have to make sure that the government is not entitled to this qualified immunity because they have violated a clearly established constitutional right. In this particular situation, the constitutional right was this unreasonable search and seizure element. Now, there was not a clearly established precedent regarding a high-speed chase and the use of deadly force. So that had not been clearly established in order to look into the qualified immunity question. So the U.S. Supreme Court had a couple of questions to answer. The first was, Does a police officer who stops a high-speed chase by ramming a fleeing suspect's car violate the Fourth Amendment's protection against unreasonable searches and seizures? And the second question was it clearly established in federal law that an officer violates the Fourth Amendment by using deadly force during a high-speed chase? Justice Scalia came in and said no to both questions. Justice Scalia went on and said, the majority held that it's clear from the videotape that Harris had posed an actual and imminent threat to the lives of any pedestrians who might have been present, to other civilian motorists, and to the officers involved in the case. Now, he used a balancing test, and he said in this particular situation, it was absolutely reasonable for a police officer to use deadly force to prevent harm to innocent bystanders. There was some argument that there weren't very many people around and so on, but Justice Scalia was not persuaded by that, and he said that the defendant was clearly showing he was driving irresponsibly, and therefore law enforcement did what they needed to do in order to secure the safety of those around. Now, even to the point of putting the fleeing motorist at serious risk for injury or death was allowable in this particular case. So Mr. Harris lost his suit, everything was tossed out, qualified immunity was established. This is Justice Kennedy, and he wrote the majority opinion for a 5-4 decision called Florence v. Board of Chosen Freeholders of the County of Burlington, which was decided by the U.S. Supreme Court in 2012. This case has to do with whether or not a strip search when you're going into jail is unconstitutional under the Fourth Amendment to the U.S. Constitution. Let's get into the case. This is Albert Florence. He was pulled over by law enforcement, and law enforcement pulled up that he had a warrant. So they arrested him and took him to jail. Within approximately 7 days, he had been searched twice by the jail personnel in order to go through standard operating procedures for him to be booked into jail and then moved. Now, later it was found out that the warrant was invalid. Everything had already been taken care of, and so he had no criminal charges, and the warrant itself was on a traffic ticket, a very low-level, non-violent, non-drug-related offense. Because he had gone through this search multiple times, he sued, and he said, look, you guys violated my constitutional right to be free from unreasonable searches and seizures. This was a low-level, non-violent traffic violation, yet the type of intrusion that was done for these searches was way out of line. All the way up to the U.S. Supreme Court it went. And the question that the U.S. Supreme Court needed to answer was, does the Fourth Amendment permit a jail to conduct a suspicion-less strip search whenever an individual is arrested, including for minor offenses? Now, in a 5-4 decision, Justice Kennedy came in and said, yes, they can do these kinds of searches, and yes, they are intrusive, but because the possibility that this person could have contraband and that contraband could get into the general population was such a huge risk that it outweighed the invasive search. And even though it was a minor offense, we still needed to keep everyone in the general population as well as the officers safe. Justice Kennedy also specified, look, if you look to the Timothy McVeigh situation, he was pulled over because of a traffic ticket, and we all saw what happened after that. So just because it's a minor offense doesn't mean that you do not need to undergo a search if that's the protocol for the jail that you're about to go into. He lost his case, there were multiple dissents, and this remains a very controversial opinion to this day.